Yes, people. So we did schedule 1 and we did schedule 2. Basically, every schedule talks about a manner or a procedure on how do we make investment. Yes. So, sir, now we are coming to the third schedule. Third schedule talks about people manner of making overseas investment by a resident individual. Hey, that one first two was a Indian entity. Now we are coming to individual, you and me. If we have to make overseas investment, what is the rule is what we are going to see. Now see, focus. Schedule 3, OI by a resident individual. Now first question, sir, can we do this? Is it possible? I mean, can we invest? First things people, they say ODI or OPI, whatever you do, whether you want to make overseas direct investments or you want to make overseas portfolio investment, it can be done subject to LRS. Sir, LRS somewhere we have seen, sir. Hey, you guys have seen it in your LRS, the FEMA part where we say per annum it is $250,000. The same thing will apply here. Okay. Overseas investment can be made by. So how and all I can make, sir? ODI in foreign entity. Sir, I can make a overseas investment itself. Yes, I can make. Sir, how? I can make ODI in a foreign entity. So individual wants to make a ODI. Basically, imagine something into equity. He wants to invest it Sims. Now, what are the conditions? Okay, he can make in a foreign entity. That is first one. Second one, that entity should not be in financial services. So these people should not be in financial services. That can be banking, that can be insurance or stock trading. It can be any other thing. They should not be into financial services. And no subsidiary or step down subsidiary if individual has control. Sir, now what do you mean by this, sir? The law is telling people basically it's a together a condition to be read together. Now what is that once you see in this? Because after seeing this, after going home, you will get confused. ODI in an operating foreign entity, it should not be engaged in financial services. Okay, so it is not engaged in financial services and which does not have subsidiary or step down subsidiary where the individual has control in the foreign entity. Meaning what, people? I cannot invest in a foreign entity which is into financial services. Second thing, people, if at all I have a control or if I want to acquire the control, over that foreign entity, such foreign entity should not have subsidiaries or step down subsidiaries. Sir, two things. What did we see? Sir, if at all I want to make ODI in a foreign entity, that foreign entity should not be into financial services. Second one, if at all I am having control or if at all I am acquiring the control, then the foreign entity should not have subsidiary or step down subsidiary. If at all they have, I cannot make an investment is what they are telling. Understood the first condition? If at all an individual wants to invest, people, then there are two conditions you need to keep in mind. One is, people, this person should not have not be making the investment into financial services. The second one, people, this person, if at all he is having control, then there should be no step down subsidiary or subsidiary. Simple one. Next one, people, OPI by way of reinvestment is allowed. What is reinvestment? I have told you. I had already invested. Now I can sell it with money. Whatever I get, I can again invest. That is allowed. Okay. ODI or OPI by way of. Sir, I can make ODI or OPI. In the first one, we are seeing that you can invest money. Now you are seeing, people, you can invest money. How and all you can invest? First one, people, capitalization, just like an Indian entity. Imagine I have supplied some raw material or the company has to give me some money. In return of money, I can take equity. That is allowed. Imagine I have supplied raw material. I'm telling no for the funds. I'm asking shares in return. Allowed. Okay. Next one, people, swap, merger or demerger. When will this happen, people? Imagine I had invested in company X. Sir, they are merging with company Y. So they will take my shares and they'll give me the new shares of XY entity. C, people, rights or bonus. I was already a shareholder. I'm getting rights issue or bonus issue. Next one, people, gift. Someone is gifting me. Who will have such rich friends? You have a. Next one, people, inheritance. A person is there, dies, you're getting. Sweat equity. Sweat equity, people. What is sweat equity? You're working for a foreign company. and you're working so hard that you have given some IP, intellectual property, you have given them some value and all. So they want to say congratulations, thank you. So in return, people, they are giving you some shares. That is called sweat equity. Qualification share. What is qualification share? In US and all, people, in India, it's not a very big rule as such. In US, they follow. What is qualification share? Imagine if I have to become a director of Google, I need to hold at least some percentage of shares in Google. Now, if at all the condition of the company is that if you want to become a director there, if you want to become a CEO there, you need to have some shares. Then no matter what, you need to hold it. You don't have a choice. Now that is called as qualification share. To become that, that is an eligibility. Next one, people, ESOP. ESOP again is a share given to the employee. Sir, note, this is important note. It makes sense also. See, ODI in E, F, G, H. So you are making ODI through these 4 conditions. May be made irrespective of the companies in financial services, or even if you have control, even if it has a subsidiary, it's still fine. Understood? People, imagine someone whom I know. Imagine there was X. X had invested in a bank outside, in a Standard Chartered bank. X passed away. X's relative got everything. His children got everything. Now he got the shares of Standard Chartered Bank. Financial services, no. According to our condition, he cannot invest, no. Through inheritance, if it happens, it's okay. In the same way, if X is the employee in Standard Chartered Bank, sweat equity allowed, ESOP allowed, qualification share also allowed, whether it is financial sector or not, because obviously, no, that is the nature of the transaction. It is allowed. See, makes sense. That is what I'm telling you. It is nothing you need to ratta marana. Yes, sir. Next one, sir. Acquiring less than 10% under FGH. FGH, sweater qualification ESOP. If you are acquiring shares under these 3 conditions and you are acquiring less than 10%, it will still be treated as OPI. When we saw example of OPI, when I gave you the definition of OPI only, I gave you the example. Imagine I invest in a company. If it is less than 10%, what is the name you give it? You give the name as OPI only. That is what they are also telling. Clear? Okay. So, sir, the first condition, what people, can an individual make ODI allowed, sir? Sir, one condition is that financial sector not allowed. And if you have control, then the foreign entity should not even have subsidiary or step down subsidiary. If they have, you cannot invest. That is one thing you need to remember. Okay, sir, fair enough. Next one is how you can invest. We saw the methods of investment. Okay, next one, people. Acquisition by gift or inheritance. Sir, you're getting the share by gift or inheritance. Then in this cases, what is the rule? First one, by inheritance, a person is dying. If you're getting how many worth of shares you can get, no limit, people, obviously. That will be considered as your own property. Then there is no limit. Next one, by gift from PRI, who is a relative. Meaning, people, I am also a PRI. There is one more PRI in India only. Both of us are in India. He gives me share. Hey, India to India, no problem. There is no limit at all. The transaction is taking place in India, it seems. Sir, what if there is a gift from PROI? So, sir, I am in India. My relative is outside India. From there, he is gifting me, sir. Sir, somewhere we are remembering some condition. Hey, there was something called as Foreign Contribution Regulation Act. Whenever your relative gifts you, the maximum that you can accept is 1 lakh rupees. I hope you guys remember. There is an amendment here also. We'll be doing it in Foreign Contribution Regulation Act. This 1 lakh now has been made 10 lakhs. Remember that. That's how we'll be doing. That's the only amendment also, but we'll be doing. So third one, sir, ESOP. Sir, with regards to ESOP, they have given you some condition it seems. What is that? So individual is acquiring ESOP. Regarding that ESOP, what is the condition? We'll see. Sir, a resident individual who is an employee or a director of an office in India or branch of an overseas entity or a subsidiary in India. So, sir, is an employee of an office in India or the branch of an overseas entity or a subsidiary is in India. Branch is in India or office is in India. Of whom? Of the overseas entity. Yes, sir. Or of an Indian entity in which overseas entity has a direct or indirect equity holding. So, sir, there is some foreign entity outside India. They have a branch. They have an office. No, sir, we are Indian company only. It is not theirs. Okay, if a foreign entity has a holding in Indian entity, Flipkart, Walmart, foreign entity having control over Indian entity. Sir, in such cases, what they are telling? May acquire an individual. An individual may acquire without limit the share or interest under ESOP, employee benefit. All this is allowed. It's absolutely problem. I mean, there is no problem. It is absolutely allowed. You can give it under ESOP, ESPS, EBS. So there are many names given to the people. It is absolutely allowed. It's clear. There is nothing else here. So that is Schedule 3. Schedule 3. Any doubts in Schedule 3? I hope this is clear. Pakka na? All of you? Okay. If you guys understood or not, do let me know. If you guys understood or not. Yes? All of you? Yes, people? So that was your Schedule 3. Let us quickly do Schedule 4. Sir, what is Schedule 4? Schedule 4 is important, people. They can ask you a question. Remember. Sir, what is Schedule 4? Schedule 4, people. Overseas investment by person resident in India. Obviously, PRI point of view only we are seeing. Okay, now who is this person? 1 and 2 was over Indian entity. 3 was individual. Now 4 count here other than Indian entity that we know. We have seen in Schedule 1 and 2 only. Sir, and 1 and 2. Sir, and other than resident individual, we saw in Schedule 3. Sir, then who else is left? Sir, other than Indian entity, other than individual, who else is left? People, we saw the definition of Indian entity. It can be people only companies, LLP, body corporate, registered partnership firm. No other person is called as Indian entity. Sir, apart from there, are there people still? Yes, no, da. How about trust? How about societies? Sir, if at all they want to invest outside India, is it possible? Sir, first of all, why will they want to invest? Why not? Da? Imagine today Isha Foundation, if they want to invest, there are trust only, no? Sir, is it possible or not? We'll see. Clear? Now see. Sir, okay, let us directly go to our easy part. I mean, from this part, it will be easy. Sir, registered trust or society. This is important. The other, this and this is like okay, but this is important. Sir, registered trust or society engaged in educational sector and hospitals. So people, trust and society, who can invest? Only those trusts or society who are into education sector or who have established hospitals. Only they can make a investment outside India in a trust or society. Second one, sir, to make it, how is it possible, sir? Prior approval of RBI required. Okay, we will take. Third condition. Sir, the foreign entity engaged in the same sector itself. If an educational trust is making an investment, they cannot make an investment in Tesla. Even they should also be involved in education only, is what they are telling. Hospital into hospital only. Next one, in existence for minimum 3 years. Our Indian trust or society should be in existence for at least 3 years. Trust deed or bylaws. What is this? Your company, you will have MOA, AOA, MOA. If it is a trust, they will have trust deed. If there is a society, you will have memorandum of association, or you also call it as bylaws. So a company, MOA should permit, AOA should permit. For a society and a trust, their trust deed and their bylaws should permit. That is what is this condition. So there should be no restriction for such investment. Next one, approval of trustees or governing body. In a company, your directors have to agree. In a trust, trustees have to agree. In a society, governing body should agree. That is what we have seen. Next one, permission of any required permission, if any, required by Ministry of Home Affairs or any other relevant authority. Sir, if at all according to the law, if at all there are any permissions required, if it is required, then you can take their permission also. I'm not saying go and take off first only. I'm telling you if required, take. Understood? Okay. Next one, sir. Overseas investment by mutual fund, venture capital fund, alternate investment fund. Remember people, mutual funds are also always established as a trust only. Mutual fund is always a registered trust only. Remember that. Yes, sir. Sir, can they invest? Yes, it seems. What are that? Nothing important. Sir, they may invest in foreign securities. Allowed, it seems. Aggregate limit is specified by RBI. Whatever, how much the maximum they can invest, sir, is prescribed by RBI, it seems. You have to invest it within that limit only. Okay. All such investments shall be treated as OPI. Whatever are the investments made by mutual funds, venture capital funds, alternate investment funds will be treated as OPI. Clear? Okay. Next one, sir. Opening of demat account by clearing corporation and clearing member. Sir, now what is this, sir? I'll try to explain this in a simple and easy language, but do not go into detail, not required. Now imagine people, whenever there is this foreign portfolio investors, if they want to trade in India, one small example I'll give you, if at all they want to trade in derivatives, people, they can trade in derivatives, people, after giving some collateral, like a security. So imagine if they have invested anything outside India, they have to give that security as a collateral and only then they can trade in India. Now, sir, in India, our stock exchanges, after the entire trade happens, people, the stock exchanges will have something called as clearing corporations, or you can call them as clearing members. Who are these people? These people will settle the trade at the end of the day. They will make sure that the buyer gets the shares, the seller gets the money. The job done in one particular department of stock exchange is called as clearing corporations or clearing members. Now they are telling, when a foreign portfolio investor wants to trade in India, imagine there is a situation where they have to give some collateral to you. They are giving you collateral of foreign securities. How will you hold it in India? So they are telling you, this clearing members, they can open a demat account outside India, it seems. It is allowed, it seems. Outside India, they can open a demat account. The foreign portfolio investors will transfer. Basically, you can take it as they will give that particular securities as collateral. If at all tomorrow foreign portfolio investors fails to make any payment, whatever is the securities given to us and we are holding it in demat account, we will sell that and we will take the money and we will settle that trade. So much is not there. Try to go back, revise and watch it. If you didn't understand, if not, just try to remember the words. What is the words? Opening of demat account by clearing corporation or clearing members outside India. It is allowed. Why, sir? To acquire, hold the foreign securities offered by the foreign portfolio investors as collateral. Just remember that. More than sufficient. Clear? Yes, sir. Okay. The fourth one, sir. Acquisition and transfer of foreign securities by domestic depository to issue IDR. What is this IDR, people? ADR, GDR. In short, again, I am telling you, imagine there is a foreign company called as Standard Chartered Bank. Standard Chartered Bank wanted to issue shares in India. Directly, you cannot issue equity in India. So what you need to do, Standard Chartered Bank gave their equity to a custodian outside India. So all their equity shares, imagine people around 3,000 crore worth equity shares were given to the custodian there outside. That custodian will keep those securities in his custody. The custodian will intimate one person in India called as depository. Sir, I have received the securities from Standard Chartered Bank. On their behalf, you can issue fresh securities in India. So people, based on whatever is the equity shares that is kept with custodian, the depository in India will issue IDRs, Indian Depository Receipts. Standard Chartered Bank was the first company to raise IDRs in India. So, sir, now what they are telling you people, this depository, sir, they can hold shares which are given by the outsider, it seems, in this transaction. Now see what they are telling. Acquisition and transfer of foreign securities by domestic depository to issue IDR, meaning, sir, whatever is the arrangement between depository and custodian. Sir, today this IDR will be issued to people. Basically 3 years, 5 years, some maturity will be there. After maturity, people, they may get equity of Standard Chartered Bank. So, sir, that shares will be taken from the custodian. It will be given to these people. So, this person will act as a bridge. Sir, now the question is, can he deal in such foreign securities? It is allowed. Why? Because it is his business. That is what is his ordinary business, no? So it is allowed is what they are saying. Sir, who else can make such investment? People, the other person is AD banks, people. That is their job, no? If at all you guys give any collateral, if you guys give any security, if you pledge it, if you want to transfer from PRI to PROI, who is doing all this? They are telling you AD bank can do it, it is allowed. That is the fifth condition under Schedule 4. acquisition and transfer of foreign security by AD bank. It is allowed. Why, sir? In the ordinary course of business. So, sir, 5 people. Who and all people? First one is your trust or society. Only education and hospital. Even you should be in education and hospital. You must be in existence for 3 years. That is, a person in India should be existence for 3 years. And next one, people, if at all any regulations, approvals required, you will take it. And sir, the approval of RBI will also be taken. And next one, people, the trustee should allow you, and regulating the governing body, the trustees should also allow you. Mutual fund, venture capital fund, absolutely allowed. There is no problem. Opening of demat account by a clearing corporation, that is by a clearing member, allowed, sir. That is your ordinary course of business to accept collateral from foreign portfolio investors. Next one, people, in the case of IDR, it is allowed. The last one, people, acquisition and transfer of foreign security by AD bank, it is allowed. It is clear, people, all of you? Pakka? Yes, sir. So this is schedule 4. Schedule 1 and 2, Indian entity. Schedule 3 is individual. Schedule 4 is trust and societies. This is clear? Okay. AD bank. Okay. The last one, sir, schedule 5. Sir, overseas investment by IFSC by person resident in India. Overseas investment in IFSC by person resident in India. What is happening, people? There is a PRI. Sir, there is IFSC. Let us take which is the IFSC we know. Not we know. There is only one IFSC in India. That is Gift City. Now, in Gift City, people, there are a lot of companies. Every floor has at least some 10 to 15 companies. More than 200, 300 companies are there in IFSC. Now, sir, we saw from this regulations point of view, IFSC is treated as foreign territory only for us. Sir, now the PRI wants to invest here. Sir, for that, what are the conditions is what they are telling. There are some conditions, it seems. Now, what are the conditions, sir? Sir, first one, PRI may make overseas investment in IFSC in India within the limits prescribed, it seems. What is it and all is not there in the syllabus, so forget. But you can invest, absolutely no problem. Sir, now we have a question. What? You're telling PRI can invest in IFSC. Yes. This PRI, who can it be, sir? People, this PRI can be Indian entity. Sir, this can be individual. Sir, this can be trust to society. Absolutely allowed. Ayo, sir, then for them, different schedules are given. No. People, nothing. Whatever you guys saw in schedule 1 and 2, schedule 3, schedule 4, same limits, same procedures, same conditions will apply even in schedule 5. That is what is given here. Overseas investment as per schedule 1 to schedule 4. So depending upon who is making the investment, you need to follow the same schedules. Nothing more, nothing less. Okay. In case of any ODI requiring financial sector regulators approval, on application made, it shall be decided within 45 days. Imagine if at all any investment requires financial sector's regulators approval. Sir, in such case, if you make an application, you need to get a reply within 45 days only, it seems. You will get a reply whether you can go ahead or not go ahead within 45 days. Okay. Indian entity not in financial services. Meaning, sir, there is an Indian entity. They are making an investment in IFSC. Okay. And this Indian entity is not into financial services systems. They are not into financial services. Okay. Sir, they want to make a ODI where they want to make a ODI in a foreign entity. Now, this foreign entity is in financial services. Let us take Standard Chartered Bank. Okay. Except bank or insurance. So, sir, this financial services, that foreign entity is in financial services, but they should not be into banking or they should not be into insurance systems. The rest of the sectors I can make it. Rest and all, what is there, people? Stock exchange, mutual funds is there. What else? PFRDA, pension funds are there. More are there, no? Sir, even without meeting net profit criteria, people, if you guys remember, if an Indian entity wanted to invest, people, we had seen that one condition, if you remember. What is that? Can you see this net profit preceding 3 years? They should have been net profit. If you remember, in schedule 1. If at all an Indian entity wants to invest in a foreign entity, is it possible? Yes, we had seen one thing. What? First thing, if at all it is into financial sector, it is not allowed at all. But if you want to do it, people, then that foreign entity should not be in bank and insurance. And you should be in that Indian entity should have been in profits for at least 3 years. They're telling you that condition itself is not applicable. It seems. See here. Except bank or insurance. Okay. You cannot invest in bank or insurance. Okay. even without meeting net profit criteria, even if there is no profits at all, you can still invest. So benefit of IFSC, good, no? Yes, sir. Okay. Next one, resident individual may make ODI. People, this was Indian entity. Now we are talking about resident individual. Can I invest? Yes, it is possible. It seems. How? I can make a ODI. Okay. In foreign entity, which is in IFSC. Okay. Including financial services. Okay. Even I can make. Here it was not allowed at all. Here they are telling me I can make it seems. In schedule 3 they said I cannot invest. Now they are telling you I can invest. Okay. Including financial services. Same thing except bank and insurance. So I can invest, but I cannot invest in those sectors, that is bank and insurance. Rest and all I can invest. Okay. Which is in IFSC. Okay. That particular entity should be in IFSC. If such entity does not have subsidiary or step down subsidiary, if resident individual has control in foreign entity. So what is the condition, people? First of all, an individual, can he invest in the foreign entity? First of all, yes, it is allowed. What about if they are into financial, if they are into financial sector, you can invest, but exception, people, that is you cannot invest in bank and you cannot invest in insurance. Sir, and after that, sir, if at all I have any control in this entity, if such entity does not have subsidiary or step down subsidiary, if resident individual has control in foreign entity, meaning what, people? If at all I have a control in the foreign entity, then it should not have subsidiary or step down subsidiary. We had seen this condition. So if at all it is there, people, you cannot invest. This is clear. So if you have control and which has subsidiary or step down subsidiary, you cannot invest. This is clear. All of you, Pakkana. Okay. Sir, note. Recognized stock exchanges in IFSC shall be treated as stock exchanges outside India. So I told you in IFSC there are stock exchanges, insurances, there are banks. Whichever company situated here will be treated as a foreign entity only. So if there is a stock exchange in IFSC, we will treat it as a foreign stock exchange only. That's the beauty. This is clear, all of you? Pakkana? Okay. So that was your schedule 5. Okay, so people, by this people, we complete rules part. We complete the rules part. Yes, sir. Sir, now what starts as, people? Overseas investment regulations. So basically, we will be talking now, till now we spoke more about non-debt instruments. That too, I'm just calling it as non-debt. It was, most of it was revolving around immovable property and equity only. Now I'll be discussing more about debt and non-fund based debt. What is non-fund based? Non-fund based is guarantee. So we'll be discussing about these two. This is clear. Okay. So sir, foreign exchange management, overseas investment regulation 2022. RBI notification dated 22nd August 2022. In exercise of powers conferred by subsection 1, 47 of the Act, the Reserve Bank hereby, the foreign exchange management, basically the Reserve Bank hereby basically pronounces or passes these particular regulations. See, I told you, rules is always by government, regulation is always by the authority. So Reserve Bank has given this particular regulation. Okay. So in these regulations, there are some definitions. What do you mean by Act? Act means FEMA only. Debt instruments, whatever we saw up, the definition will be same. What is that? Government bonds, corporate bonds, that tranches, all those things, senior most tranche, the same definition will be there, it seems. Sir, financial commitment by Indian entity by modes other than equity capital. So sir, how to make equity we saw. Sir, now financial commitment other than equity by an Indian entity. So now how can it be made? Equity we saw. Now we are making other than equity. What is other than equity? We'll see. Sir, financial commitment by Indian entity and modes other than equity capital. Okay, sir, first of all, can I invest? People remembered, if an Indian entity, if they want to make any financial commitment in a foreign entity, financial commitment means, people, I want to give a loan, I want to give debt, it can be debentures, or I want to give guarantee. All these are financial commitments. No, if I want to do this, first, people, there are some conditions you need to satisfy. If you do not satisfy the condition, you cannot do these at all. It is not allowed at all. Sir, so what are the conditions to do this? First thing, people, see here. Indian entity may invest in debt may invest in debt or non-fund based commitment guarantee. So I can give debt or non-fund based commitment. For that, first conditions to be satisfied. What is that? The Indian entity is eligible to make ODI, meaning people, you should not be prohibited from making ODI. Sir, we are studying debt. Why are they giving reference to ODI? Indirectly, people, I'll tell you one thing. Okay, first only I'll tell you of the condition. If at all you want to give financial commitment, first you should have already given ODI, meaning people, you should be already a equity holder in that entity. If you do not hold equity, people, you cannot give debt, you cannot give loan, you cannot give guarantee. That's the simple criteria, that's all. So you should have made ODI. If you have made, then you are eligible. If you have not made, you are not eligible, that's all. So people, they are telling you, according to the law of India, you should not be prohibited from making ODI. Yes sir, I am not prohibited from making ODI. I am not prohibited. I am not willful defaulter, I am no one. I am allowed, okay. So I am not prohibited. Second one, you are not prohibited, no. Then first invest. Indian entity has made ODI in the foreign entity. So I am not prohibited, correct. That's the reason now they are telling the next condition, first to make the ODI. Okay sir, next one sir. Indian entity has acquired control in the foreign entity while making financial commitment. Not prohibited to make ODI. You should have made ODI, and people, you should have control to make this financial commitment. If these three conditions are satisfied, you can make financial commitment. Sir, first of all, how much financial commitment can I make? Hey, yesterday we saw, what is that? In schedule 1 we saw 400% of your net worth you can make. No. Financial commitment. That includes your ODI, that includes your debt, everything was included, right? That is what they are telling you. So everything put together, you can make it, it seems. Sir, financial commitment, what and all I can make? Financial commitment, you can make whatever is given under Regulation 4, 5, 6 and 7 shall be counted towards FC limit. Foreign shall be counted towards shall be counted towards your financial commitment. Whatever is given in 4, add it, 5, add it, 6, add it, 7, add it. So everything put together is counted in financial commitment limit. Sir, what is this 4, 5, 6, 7? People, 4. Regulation 4 says financial commitment by an Indian entity by the way of debt. So sir, Indian entity is giving the foreign entity something in the form of debt. The debt can be debentures or loan, but I am giving you money. Okay, then what is the condition? Very simple. Sir, the presence of loan agreement between both of us, there should be something in written. Loan agreement should be there. It should not be oral. Second one, the rate of interest must be at arm's length basis. How much ever you are paying to the people in your country or to the country other than your country. Say for example, you are in US, you have borrowed loan from Singapore. How much are you giving interest to them? Sir, whatever is the interest you give to the Indian entity, it should be at arm's length basis. That should be equal. So basically, you are not supposed to get it for a lesser rate of interest. They are trying to protect your interest. That's all. That is Regulation 4. An Indian entity can give loan to the foreign entity provided there is a loan agreement. And second thing, the rate of interest is at arm's length basis. That is Regulation 4. Regulation 5. Regulation 5 is important. Remember what? Sir, 4 we gave directly loan. 5 people we are giving guarantee. Sir, the financial commitment by the way of guarantee on behalf of foreign entity. So, foreign entity, there is Indian entity, there is foreign entity. The foreign entity is doing some transaction. They are doing some transaction with Mr. Let us take Donald Trump. They are making some transaction with Donald Trump. Sir, we are giving a guarantee to Donald Trump, meaning if at all these people do not do, then we will do it. We are giving a guarantee. Yes, sir. So we can give guarantee on behalf of foreign entity, or we can give guarantee on behalf of subsidiary of foreign entity. That is what they are giving you. See here. Financial commitment by guarantee on behalf of foreign entity or foreign entity subsidiary or foreign entity step down subsidiary, where Indian entity has control. That control we saw here only, Noda. It's nothing new to you. Yes or no? So I can give financial commitment to them itself. That is allowed on behalf of them, not to them. Hey, logically think I will not give it to them. whoever is entering into a contract with these people, I will give it to them. I'm giving it to Donald Trump. So, sir, corporate, what type of guarantees can I give? I can give corporate or performance guarantee by the Indian entity. So, people directly, the Indian entity only can give. Or corporate or performance guarantee by the group companies. Group company means people. So, there is Indian entity. I will not give. My Indian entity's subsidiary company will give. Let us imagine this is Flipkart. Flipkart will not give. Subsidiary company. Let us take PhonePe will give. Sir, or Flipkart company's holding company will give. Who is holding company? Walmart will give. So, sir, the guarantee can be given by the company, Indian entity only, or any of the group companies of the Indian entity. Who are the group companies people? The first one is your holding company. The next one is your subsidiary company. Anyone can give. It is allowed with some read. The holding company. What is holding company? 51% of holding is there in the Indian entity. Someone is controlling this Indian entity. They can give. Or the subsidiary. So Indian entity's subsidiary, where Indian entity holds 51%. Simple. Or the promoter group, which is body corporate. Sir, whoever is the promoter group of this Flipkart, they can also give it sums. Basically, you call them as group companies in your language. They can give. So Indian entity only can give, or the group companies can give. Okay, the third one, see, this is good. Individual promoter of Indian entity. Individual promoter of Indian entity. Here we are seeing you people, if it is body corporate. What is this, sir? Imagine, sir, who started Flipkart? Let us take, for example, Mr. Sachin. Sachin started Flipkart. Sir, Sachin is giving guarantee now to Donald Trump. Is it allowed? Yes, it is allowed. Sir, Reliance, imagine Mukesh Ambani only gives guarantee that if at all my company or the foreign entity does not perform, I will come and give the money for it. It is allowed. Yes, sir. Next one, people. So, see, individual promoter of Indian entity gives a personal guarantee. He is only telling I will come and give. But there is a catch. We'll see in the rules. There is something about it. The bank guarantee by bank in India backed by counter guarantee or collateral by Indian entity. Now, what is that, sir? There is Indian entity. Indian entity has operations in SBI. There is foreign entity. Foreign entity is doing transaction with Donald Trump. Sir, now who is giving guarantee? SBI is giving guarantee to Donald Trump. That if at all the foreign entity does not do the operation properly, then don't worry, we will come and we will make sure that the money is paid by us. Now you guys can be thinking, why will SBI come and give a guarantee to Donald Trump? Why? How are they even related? People, the Indian entity will go and request SBI. Sir, please can you give this, the guarantee to the person there in India, I mean the outside India, that is Donald Trump. Can you please give? First of all, you guys can be thinking, why will someone ask? Okay, these people only can give. No. This will come into picture when there are trust issues. How big are you? You can fail, but the financial institution in India, will it fail? The answer is no. So I would want my loan to be more secured, my performance to be more secured. In such cases, I might demand for a guarantee from a banking sector. Now you can be thinking, why will SBI give? People, there will be a counter guarantee given by Indian entity to SBI. Meaning what? Imagine if the foreign entity does not do this particular contract properly, that Donald Trump will come and hold SBI liable. So SBI has to pay money to Donald Trump. SBI has every right to recover the money from this Indian entity because it will always be backed by counter guarantee. So bank guarantee by bank in India, SBI, backed by counter guarantee or collateral by Indian entity. Indian entity is telling, sir, if something happens, I'll give you money. Why do you worry? So you don't worry. Simple. Yes, sir. Okay. So this is people with regards to guarantee. So these types of guarantees can be there. But with regards to guarantee, there are some rules. Regarding the rules of the guarantee, people, they can ask you a question. Remember here, rules are important. What is it? Simple only. Try to focus. Now, what are the rules of guarantee, sir? First one, guarantee is given by group company. Sir, what is group company we saw? There is a Flipkart. Sir, Walmart is giving loan. Sir, PhonePe is giving loan. PhonePe is giving guarantee. Sir, in such case, you are telling you net worth, no? How much a person can give? 400% of net worth. In the net worth, what and all will be calculated? Even the amount of guarantee you have promised, that will also be calculated. Because you remember financial commitment ka definition, it includes non-fund based as well, right? So people, whatever is given by Walmart, now imagine Walmart has given the guarantee to the foreign entity, Donald Trump. Whatever is the 400% of Walmart, in its limits, people, this 400% will be taken. If PhonePe gives, in its limit, it will be taken, not in Flipkart limit. That is what they are telling. It shall be counted towards the utilization of foreign contribution limit, financial commitment limit independently. Theirs, it will be taken in theirs. It will not affect Flipkart's. Next one. Sir, what if it is an individual promoter? Individual promoter, Sachin, our Sanchit Bansal, or what is the other example I gave you? Mukesh Ambani. If they are only giving guarantee, then this is the beauty. I told you there will be a counter thing that will come. Remember this. If at all the guarantee is given by the promoter on behalf of the Flipkart, Sachin is giving. On behalf of Reliance, Mukesh Ambani is giving. People, this is the beauty. Whatever is the guarantee given by the individual, the limit will be taken in the limit of the Indian entity. Sir, we didn't understand. Imagine Mukesh Ambani promised to give for example, 1 crore worth guarantee he has given. Sir, Mukesh Ambani is a promoter of Reliance. On behalf of Reliance, Mukesh Ambani gave. People, this 1 crore will be calculated in the 400% of the net worth of the Reliance. Now, if at all Reliance wants to make any financial commitment, in that this 1 crore will be deducted. If at all it is made by an individual, if it is body corporate, you will take it in their limit. Individual, then what is the problem? The law says, people, you have to count it in your limit only. Good provision, no? Yes, sir. Remember that. The third one, no guarantee shall be open-ended. Open-ended means, people, sir, in our case, Indian entity is guaranteeing to the Donald Trump that you keep doing the business, sir, 5 years, 10 years, 20 years, 50 years. Anything happens somewhere, anytime, sir, we will only give the money. Don't worry. People, you cannot keep the guarantee open. It should have a definite duration, definite amount, definite interest, definite parties. That is called as close-ended. If nothing is there, it is called as open-ended. Such guarantees are not allowed. The next one, any amount of guarantee invoked shall form part of lending. Meaning, people, I told you, there is always two types of debt. One is non-fund based, one is fund based. Non-fund is guarantee. Fund based is direct debt. Tomorrow, if Donald Trump, imagine our foreign entity, they did not do the transaction properly. So we had to give the guarantee amount. We had to actually pay. People, whatever we pay people from non-fund based, it will become fund based. It will come into our limits of 400% as fund based. That's all. That is what they are given. Any amount of guarantee invoked. Invoke means, people, because of non-payment, this particular provision has been now triggered. Now it shall form part of lending. It will become a debt. That's all. You can recover from the foreign entity. Here, next one. Joint guarantee given by 2 or more Indian entities. Wonderful provisions here. This, if you just remember from FEMA point of view, it will not make sense. You had studied this provision when you were chota bacha. When in your childhood you had studied this provision. What I am telling you? What is that? Imagine there is company A, company B. These two people, they gave a guarantee on behalf of foreign entity to Donald Trump. Okay. Saying that the entire value of the guarantee is 1 crore. Sir, A and B give this guarantee jointly 1 crore to Donald Trump. Tomorrow, if foreign entity does not perform, we will give. Sir, this 1 crore, when we are counting the financial commitment of A and B, how should we divide it? You guys are thinking, no, sir, 50 lakh in A's limit, 50 lakh in B's limit. Correct? That is what you are thinking. The law says you are wrong. Whenever there is a joint loan given, joint promise made, people always remember 1 crore will be counted in both their limits. In A's limit also it will be treated as 1 crore only. In B's limit also it will be treated as 1 crore only. If you guys are feeling it as unfair, it is not unfair, people. According to Indian Contract Act, whenever there is a joint promise, imagine, people, if at all A becomes insolvent, A has given a guarantee, but A became insolvent. People now, B will be liable to pay the entire 1 crore to the Donald Trump. He will be liable. He cannot say, in between us, we had agreed 50 lakh each. That will not hold good. That's the beauty of joint promise. If you have made a joint promise, you are liable for the entire amount if the other person doesn't pay. So people, there is a chance that you may have to pay 1 crore. That's the reason they will take 1 crore towards both your limits. Understood? That is what is given here. See, joint guarantee given by 2 or more Indian entities, 100% of guarantee shall be counted towards the individual limits. 100% is taken. The next one, people, is called as performance guarantee. Performance guarantee, we had seen it in your previous provision also. Performance guarantee, people, we will tell, if at all our foreign entity does not perform, then we will perform that particular obligation. We will do it. Your performance is guaranteed. Yes, sir. Sir, how much worth you have given? People have given 1 crore worth promise. If he does not perform, I will give the 1 crore. Imagine foreign entity. They promised to give 100 Teslas. They promised to deliver 100 Teslas. Sir, what is the value? Let us take the value of 100 Teslas comes to 100 crore. So we have given guarantee for the performance, for the delivery of 100 Teslas to Donald Trump. How much value, sir? How much of the value I have guaranteed? I have guaranteed 100 crore. The law is telling people, whenever if foreign entity does not perform, if Tesla is not able to deliver 100 crore worth, then I will have to give that. No, you'll have to compensate that. No. People, when the Indian entity has promised, we are guaranteeing no to Donald Trump that we will come and help you if at all there is non-performance. I have promised for 100 crore only. But when I'm adding my limit for the 400% of net worth, when I'm counting, I will not take whatever I have guaranteed as performance guarantee. I will not take the entire 100 crore. I'll only take the 50% of the amount of performance guarantee I've made. I've guaranteed 100 crore. I will not take 100 crore for counting my limit. I will take only 50 crore here. The logic behind this is, people, whenever a foreign entity has got a contract, it is logic that people, they will not fail to deliver even 1 crore. We will be a little optimistic that at least 50% they will be able to deliver. If not, they wouldn't have taken the contract at all. Even if there is a non-failure, people, the failure can be for the maximum 50%, not the entire part. So when you are counting the limit to the Indian entity, you will be counting it as 50%, that is 50 crore only. Even though in reality I have given 100 crore. Just remember that. It is clear, all of you. But if you remember in the class, people, on this I had given you a big detailed explanation only. Yes, sir. Okay, that is what we have seen. And the next ones are rollover to same extent, not considered as fresh financial commitment. What is this, sir? Sir, in 21, so let us take in 2023, we had given a performance guarantee. Sir, 2023 is done. There is no default and all. In 2024, again they asked us to give guarantee. Sir, whatever we had given here, we can just continue the same agreement. Whatever we had given previously, we can just keep on continuing the same agreement. The continuation of the previous agreement only is called as rollover. Rollover means, people, whatever we had done previously, that you can keep on continuing. So, sir, should we count the previous years and this year's as two different limits? No, people, this and this, there is no difference. No, the same amount you are continuing this year also. You will not again count it freshly. Whatever you have taken towards 400%, in that this year's is included. Again, you will not include. It will not be treated as two transactions. It will be treated as one transaction only. It is allowed. That is what is given here. Where is it? Rollover to same extent, not considered as fresh financial commitment. It is clear, all of you? Yes, people. So we are done till regulation 5. Regulation 5 is done. So now, people, let us do with regulation 7. So regulation 4, 5, 6, 7 are counted in whatever we are calling as financial commitment that is made by our PRI. So that is what is 4, 5, 6, 7. Okay. What is 6 and what is 7? Simple one, people. 6 talks about pledge. and charge. 7 talks about acquisition of transfer by deferred payment. Now, what do you mean by that? Let us refer this in our book. Simple provision, nothing much deeper and all. Okay, now what do you mean by regulation 6? Yes, people. So what does regulation 6 say? An Indian entity which has made, people pay attention, which has made, so you should have already made ODI by way of investment in equity capital in a foreign entity, they may also do this, it seems. What is that? They can pledge the equity capital of the foreign entity. So, sir, whatever is the PRI, whatever is the ODI you have made, this ODI can be pledged, it seems. That is what they are telling you. It can be pledged. Pledge the equity capital of the foreign entity in which it has made ODI or the step down subsidiary or subsidiary. Yes, sir. Sir, it can be done. Sir, in whose favor I can pledge this? You can you can create a pledge in the favor of these people. Who are they? AD Bank, PFI, and overseas lender. So if these people are giving us loan, we can use these securities, basically these shares, as collateral, and we can take what? We can take what? See, for availing fund-based or non-fund-based facilities. So you can give us collateral, people, you can use this. And whatever is a pledge, basically it is collateral, right? They are telling you even for collateral, this is considered as financial commitment. It is considered. That is what they are telling you. Sir, the first part talks about pledge. The second part talks about charge. Pledge, basically, people, I'm talking about shares here. You can pledge the shares. Pledge, we use it with regards to goods, movable goods. When will I use the word charge here? Charge, people, basically I'll use it for a broader term. It includes, see, mortgage, pledge, hypothecation, or any other thing. Basically, wherever you're borrowing some loan, people, and you're giving this particular asset as a collateral. So this can be even immovable property. A only is your shares. B can be your immovable property as well. Okay, now see, it's assets in India. So what are they saying? You have to read it like this. An Indian entity which has created ODI can create charge by way of mortgage pledge on assets in India. So my Indian entity, PRI, sir, their assets in India, on this they can create charge, it seems. Obviously, people, in your childhood you would have studied what is charge. Basically, whenever you are borrowing loan, you are creating a security to the other person. That is called as charge. That is what they are telling. So you can create it on the assets in India, including your group companies assets, on your associate companies assets, promoter or director in favor of. So you're giving it to these people, AD Bank, PFI, or any other overseas lender. So with regards to them, you're creating, basically you can take it as land. First A is only shares as security for availing fund-based or non-fund-based. So you can ask guarantee or as well as debt for any foreign entity in which it has made ODI or for its steps down subsidiary or outside India. Now, what are they saying, people? The Indian entity can create charge in the favor of PFI or your AD Bank or any overseas lender. Sir, why are we doing it? Because we are getting fund-based or non-fund-based facility. Sir, who is getting this? This is taken by the foreign entity. In whichever entity we have made investment. So we are giving a security for them. They are taking. Yes, sir. Now see, that is what they are telling. For any foreign entity in which it has made ODI or it's a step down subsidiary. Yes, sir. Or you can create a charge on assets outside India. Indian entity, if at all I have any assets outside India, on this also I can create charge, it seems. The only thing here is you are creating a charge outside India, right? Sir, for what are you creating? Again, fund-based, non-fund-based. Okay, who is taking? This can be foreign entity who is borrowing the money or the Indian entity who is borrowing the money. That's why FEMA provision is coming, no? If you're seeing the cross is happening, Indian assets are used to give foreign assets. Foreign entity we are giving. Here, Indian entity is using outside India for foreign entity or even Indian entity. We are taking that particular assets as charge. That is also allowed is what they are telling. See, foreign entity in which it has made ODI, AD Bank in favor of PFI for availing fund-based, non-fund-based for itself or any foreign entity. Here, you can even create this in the favor of debenture trustee. When will debenture trustee come? Whenever if you have issued secured debentures. So you can create even in the favor of debenture trustees also what they are telling. Yes, sir. Okay. Sir, but one thing we need clarification. What is that? You are telling that this pledge or charge, whatever we are creating. Sir, this pledge or charge is considered as financial commitment. Correct. It is considered as financial commitment. But we have a doubt. What? Sir, the maximum financial commitment is 400%. Now, what value should we consider towards our financial commitment? What is the value? They are telling the value of the pledge or charge. How much will be considered towards financial commitment will be the value of the pledge or the amount of the facility, whichever is less. Meaning people, whatever is the value of your asset, you have given as collateral, or whatever is the loan you got, whatever is the guarantee you got, I'll just take loan. The value of the asset or loan, whichever is less. So, sir, that value will be taken towards our 400% of our net worth, financial commitment. Clear? This is okay, easy. I'll not say important and all. Okay. Second one, sir, you're telling that I can create a charge or pledge in the favor of AD Bank, PFY, money lender. From which country this person should be? This person should be from such country. From such country where we do not have any prohibition over such countries. Simple people, you should not be from Pakistan. Basically the money lender. Okay. Sir, the creation of enforcement shall be in according to these regulations and rules. Okay. Whatever is public financial institutions, it will be same as seen in Companies Act. Basically LIC, IDFC, that will come here. Sir, the negative pledge or negative charge or the bid bond guarantee obtained in accordance with these regulations shall not be reckoned. Reckoned means people counted towards the financial commit referred to sub-regulation 1 of regulation 3. Sir, now what do you mean by that, sir? In certain cases, people, there is something called as bid bond guarantee. What is bid bond guarantee? Now, for example, people, imagine I'm going for bidding. You imagine like this, the simple example I'll give you. I'm participating in IPL bidding. So CSK and Mumbai Indians are fighting. CSK says 5 crore, Mumbai Indians says 6 crore for Dhoni. CSK says 7, they say 8, 9, 10. This is going on. Now imagine finally CSK says 20 crore. Now the bid is won by CSK. Now Dhoni should go to CSK. Now when it is asked to pay, CSK do not have money. This can happen. Now the entire time, the process, the procedure, everything is waste of time. Now imagine if this happens in the overseas transaction. If you are participating in any bid, but the person whoever is calling you for the bid, he is not sure whether you are going to, do you have that financial, financial commitment? Do you have so much of financial backup so that once you win the bid, you will be buying or selling whatever you have agreed? So what is the guarantee? They say whatever is a bid bond guarantee. Certain times they will say whoever is participating in the bidding, you need to give a bond as a guarantee that you are having some money. I'm guaranteeing that I will pay. So any guarantee given for bid bond guarantee, this will not be counted in the limit of financial commitment is what they are telling. Generally people, because this is temporary in nature, that's the reason. Yes, and what else will not be counted for financial commitment? Next one is negative pledge or negative charge. What do you mean by negative pledge or negative charge? That's the problem with this regulations and all. They will use fancy words, negative pledge and negative charge. But are they defined in this act? They are not defined in this act. So what do? We refer to the others outside thing, and whatever is the meaning there, we take it here. So what do you mean by negative pledge, people? Whenever a loan is taken, imagine Indian entity is borrowing loan from a foreign lender. Sir, now in this loan, this Indian entity has given a security, collateral. So they have entered into a loan agreement. Now money lender says, I want one clause to be included. What is that clause? The clause is called as negative pledge or negative charge. Now whenever such clause is written, people, the asset whichever is used here, if you have used it once to take the loan, on the same asset you cannot borrow any other loan, or you cannot give the same asset as security for any other loan. That's the meaning of negative pledge clause. So if the money lender has included in your loan agreement on the same asset, you cannot create any further pledge. Now imagine using the same asset if I have created any other pledge. The law is telling obviously that is not valid, because according to this agreement, that pledge, even if it is valid, even if you do not pay, they cannot take, because this person has the entire right over this. So the law says even if you create a second collateral using the same particular asset, the law is telling you need not count it towards your financial commitment. All this is nowhere defined. They have just used the word negative pledge or negative charge. But what is the meaning? This is the meaning. Understood all of you? Pakka? Okay. So this is regulation 6. Next one, sir. Regulation 7. Acquisition or transfer by way of deferred payment. Now what is that, sir? Imagine people, a PRI is buying shares from a PROI. He's buying shares from PROI, or a PRI is selling shares to a PROI. So I can be buying shares or selling shares. Both the provision, this particular regulation will apply. Okay. Now what are they saying, people? In a transaction, whenever you're acquiring shares or whenever you're transferring shares, with regards to whatever is the money involved, people, if you do not collect it upfront, imagine if you do not collect it straight away at the time of transaction, you're telling him to pay it afterwards, after some time. Now this is called as, people, deferment of payment, or it is also called as deferred payment. Now people, you have not yet received the money, you are going to receive. Now how shall I treat it as? You have not yet paid the money, you are promising that you will pay the money. How shall I treat it as? They're telling you that deferred payment will also be counted towards your financial commitment, whatever is the amount. Yes, sir. So regarding that, there are some rules. What does that see? So PRI acquires equity from PROI, PROI from PRI. Where such equity is reckoned as ODI, so it is considered as ODI, the payment of amount of consideration for the equity may be deferred, may be postponed, subject to following terms. What is that? First one, the foreign securities equivalent to the amount of total consideration shall be transferred or issued, as the case may be, upfront by the seller to the buyer. So whatever is the shares, you should have first given it away. Yes, sir. Money should be postponed, not the shares. Shares should be first given away by the seller to the buyer. The full consideration finally paid shall be compliant with the applicable pricing guidelines. Initially, we saw when we started this amendment, pricing guidelines, it should be at the arm's length transaction. So it should be considered as arm's length transaction only, provided that the deferred payment of equity capital shall be considered as non-fund based commitment. So, sir, whatever the PRI, they are telling you, the deferred part of consideration in case of acquisition of equity of a foreign entity by a PRI. Sir, in the first case, when PRI is acquiring the shares of PROI, sir, whatever is the money you need to pay, the money will be considered as non-fund based commitment. Basically, people, it will be treated as a guarantee. We have not yet paid, no. So it will be treated as non-fund based commitment. You will have to pay someday. This is clear, all of you. That is what is given here. The buyer may be indemnified by the seller up to such amount and subject to such terms and conditions as may be mutually agreed upon between them. Indemnified, if at all the buyer suffers any loss in this transaction, seller may indemnify by the buyer. Yes, sir. Buyer may be indemnified by the seller. Okay. So, sir, now that is, people, your regulation 4, 5, 6 and 7. Is this clear, all of you? So 4, 5, 6, 7, all of these are considered as financial commitment by Indian entity in modes other than equity capital. So how and all you can do, people? Regulation 4 says about debt. Regulation 5 talks about guarantee. Regulation 6 talks about pledge and guarantee, pledge and charge. Regulation 7 talks about deferred payment. All these are considered as financial commitment, it seems. Okay. Next one, mode of payment. Sir, you are paying, no, this is considered as financial commitment. How and all you can do this? The first one, you can do it by banking channel. You can make the payment by banking channel. Second one, out of the funds held in the account, accordance to this particular provision of the act. It can be RFC account, EEFC account, Through that also you can make this transaction. Swap of securities. I'll give you my equity, or I'll give you something else. I'll take debentures. I'll give you debentures. I'll give you equity. So basically I'm creating a debt. Or by using the proceeds of ADR, GDR, stock swap or ECB, whatever we had seen up in the case of ODI, same thing. You can issue those securities, whatever money you get, using that you can make this financial commitment. Is clear? So this is your regulation 8. Next one, people, regulation 9. Regulation 9 can be important. What does regulation 9 say? Concentrate. Obligation of PRI. So a person resident in India, when he is making all this financial commitment, he has some obligation it seems. What is that obligation, people? Obligation number 1. PRI acquiring equity shall submit to the AD bank the share certificates as evidence within 6 months. What is this, people? PRI is telling that, sir, I am investing outside India. Correct? Yes, sir. I am investing in the foreign entity. People, when you are investing outside, people, this person would have given you some share certificates. Something evidence should be there, no, people. The law is telling, once you have made an investment, within 6 months, people, you need to bring this share certificates back to India. You have to give it as an evidence to people, our AD bank, as a proof of evidence of the remittance. Sir, 6 months from when? 6 months from remittance, from the day you sent the money, or date on which dues are capitalized. Sir, I did not send money. I had sent goods. I told them to capitalize the goods into shares. I told them to convert. So whenever the decision was taken, on that day, people, from that day, 6 months, you have to make sure you have to bring the shares as evidence and you have to submit it to the AD bank. First one. Second one, that is obligation number 1. Second one, PRI to obtain UIN, unique identification number. Why? And from whom? Sir, I need to get this from RBI for such foreign entity through AD bank before outward remittance or acquiring the equity, whichever is earlier. Now, what is this, sir? Whenever I'm making a transaction, people, I need to register my transaction with RBI through AD bank. So for my transaction, they will allot me a number, unique identification number, which is specific to that particular foreign entity. If I'm making 2 transactions, it will be 2 different unique identification number. Now imagine we are all investing in a particular equity. If more than one person is investing in that particular equity, which belongs to the same transaction, all the PRIs have to do this transaction through the same AD bank. Imagine we went through ICICI Bank. ICICI Bank generated this UIN. If at all it belongs to the same transaction, all of us, all the PRIs have to do this transaction through the same ICICI Bank, through the same AD bank. That is what is a note given here. PRI to obtain UIN from RBI for such foreign entity through AD bank before sending the money or acquiring the equity. So before you send the money or before you acquire the equity. If you are thinking, sir, without, why are they giving whichever is earlier? Hey, we saw no deferred payment. You could have acquired equity first. You can make the payment also later. That's the reason. More than one PRI making financial commitment to route all transactions relating to same UIN, same transaction through the same AD bank. More than one PRI. If you and me are doing a transaction for a same foreign entity relating to the same UIN, we have to do it through the same AD bank. Not so important, but remember, PRI shall realize and repatriate to India all dues arising. Sir, I have invested. Whatever is the money I may derive, it can be by, say for example, I have invested. Now I am selling the investments outside. We saw that, right? You have to give an undertaking. What is that, people? I am going to realize, that is bring back the money, and I am going to get it back, and I need to, what is that? I need to repatriate and realize. After bringing back, I need to go and convert it to the Indian currency. Sir, within how many days? By, if at all you are doing transfer or disinvestment, or if you are doing liquidation, within 90 days of that particular transaction. So I need to realize and repatriate. If at all I am transferring, basically if I am giving it as a gift or giving it to someone else, or gift doesn't arise. If at all I am selling it to someone, Disinvestment, again selling it to someone. Liquidation, the company is only winding up. So I'm getting back my proceeds. Whatever I had invested, I'm getting back that money. You have to do it within 90 days. Is this clear? Okay. And next one, if at all there is any open-ended bid guarantee, if any, shall be converted to close-ended within 3 months from award of the contract. What are those people? First of all, people remember, you can never give open-ended guarantee, which is not at all allowed. We have seen this in guarantee. Regulation 6, we saw this. Sorry, Regulation 5, we saw this. Now, people, what they are telling, imagine if at all there is any open-ended bid guarantee. What is bid guarantee? I told you. If you are participating in any contract, to make sure that you get the contract, you may give a guarantee. They are telling you, if at all that particular person is if at all he is demanding for an open-ended bid. Sir, can I do it? Yes, you can do it. Provided that open-ended bid should be converted to the close-ended bid within 3 months. Sir, within 3 months of when? Within 3 months of you getting the contract. You are participating in the bid, right? If you get the contract within 3 months from getting the contract, you need to convert the open to the close-ended bid. That is what they are telling. It's clear? This is Regulation 9, people. Simple, all of you. Yes. Okay. Next one, people, is Regulation 10. What is Regulation 10? People, Regulation 9 is obligation of PRI. Regulation 10 is reporting requirements of overseas investments. Sir, now what is it, sir? You're reporting something, it seems, people. Whenever you're making any overseas investment, you need to report something, it seems. People, reporting can be important. Sir, what is this reporting I need to make? The reporting, people, first thing, all reportings is to be made to the AD bank. So to whom should I make? I need to make it to the AD bank. When, sir, the PRI, if at all you are making any financial commitment. Sir, from the time of remittance or making the financial commitment, whichever is earlier, I need to make the reporting. So when should I make, people? If at all I am making financial commitment, from the time of remittance or making the financial commitment, whichever is earlier. We are using time of remittance for basically fund-based. Making financial commitment, more non-fund-based. So if at all such things are happening, whichever is earlier, I need to make a reporting, it seems. Okay. So if at all I am making disinvestment. Disinvestment means, people, I am selling or I am liquidating. I need to report it within 30 days of receipt of the proceeds. I get the money, I need to make a reporting to AD bank. Third one, if at all there is any restructuring, compromising and all, within 30 days of restructuring, I have to make a reporting to my AD bank. Simple, yes, okay. That is first reporting. Second one, PRI other than resident individual. So imagine a foreign entity or any other trust or society. If at all you are making, or if you are transferring OPI, if you are investing in OPI or if you are transferring OPI, overseas portfolio investment, then you need to report it, it seems. Okay. Report it within how many days? You have to report it within 60 days from the end of half year. That is, people, September or March. Meaning, people, imagine they have categorized the reporting as 6 months. If you are making any OPI between this time, imagine you are making any OPI in the month of October, November, December. Imagine I am making the OPI in the month of December 2023. They're telling me I need to report it by the end of March. Sir, from end of March, I have 60 days time. So within 60 days, that can be, people, April and May. People, in the May, people, I need to exactly count 60 days. Probably that can come to May 29th. So people, by May 29th, I need to report of any investment made in December. In the same way, imagine I made an investment in the month of May. If you have made in May, people, then you need to count 60 days from the month of September. If at all you have made OPI, do not get confused. See, PRI other than resident individual, making, people, OPI, he needs to report within 60 days from end of half year, that is September or March, as the case may be. Yes, sir. Sir, this is other than resident individual. What if it's resident individual? People, if you are resident individual and if at all you are investing in ESOP, an Indian is getting ESOP. The law is telling this person need not report it, it seems. On behalf of him, whatever is the Indian entity, the office in India, branch in India, they have to report it to the AD bank, not the individual. That is what they are telling. Clear? Read once. Note, in case of ESOP, reporting is to be done by office, branch or subsidiary in India. Is this clear all of you? Okay. PRI acquiring equity, that is ODI. Sir, the PRI, the person resident in India, if they are acquiring ODI, sir, then what are the reporting you need to do? First reporting, you have to submit something called as annual performance report, called as APR. What is this, people? Basically, how much have you invested? What is the ODI you have done? What is the other things you have done? What is the debt, if any? You have to give a clear bifurcation. How much you have carried forward from the next year? Anything new investment made? So you give a detailed report, people. That is called as annual performance report. You have to give it, people, for each of the foreign entity. Meaning, sir, if PRI has invested in Tesla, has invested in Apple, he has to file one APR for Tesla. He has to file one APR for Apple. You have to submit for each of the foreign entity. Sir, by when? You have to submit it by, people, 31st of December. You have to submit it by 31st of December. But remember, people, if the foreign entity follows a different accounting year, if they follow a different accounting year, then the law says, now imagine for the year 21-22, if they are following a different accounting year, instead of submitting it by December 2022, instead of submitting it by December 2022, they can submit it by December 2023. If at all they are following accounting year where they are following from January to December, if their year is ending on December 2022, they can file APR by December 2023. In any other case, people, you will file it by December 2022. That is what is the reporting. See, annual performance report for each foreign entity by 31st December, every year you have to file. If year ends on 31st December, then by 31st December of next year you need to file. Is this clear? Pakkana? Sir, so every PRI should do it. Every PRI should do it, but there is two exceptions. What is that exception? You need not submit this APR when? If there is a PRI, if he is holding less than 10% of equity and he has no control and he should have not made any other financial commitment. If a PRI has invested less than 10%, he has no control over it and no other financial commitment made. In such case, people, such PRI need not submit an annual performance report. First exemption. Second exemption, a foreign entity which is under liquidation. Sir, whichever I have invested, that company is winding up, people, I need not submit a APR on such foreign entity. Third one, people, in case more than one PRI have made ODI, the person holding highest stake shall submit APR. What exactly is given in APR, people? The person resident in India shall report the details regarding acquisition, setting up, winding up, transfer, step down subsidiary, alteration in the shareholding pattern in the foreign entity during the reporting year in the annual performance report. So whatever, people, how the foreign entity is performing, in addition to that, what is my contribution, you will be including in it. Is clear, all of you? Pakkana? Okay. Sir, and fourth reporting you need to do, the Indian entity which has made ODI shall submit something called as annual return on foreign liabilities and assets. It's popularly called as, people, FLA. You guys would be knowing this. If at all there is any Indian entity, if at all these people have any assets outside India, if these people has any liabilities outside India, if they have assets or liabilities, every Indian entity has to submit a report to RBI, and that is called as, people, FLA, foreign assets and liabilities. Foreign liabilities and assets. Sir, by when should we file? This is not there in your syllabus, people. You need to file it by July 15th. Every year you have to file it. This is clear, all of you? So that is, people, regulation 10. Yes, sir. Okay. Next one, sir. Sir, what if there is a delay in reporting? What do you mean by that? Sir, a PRI not submitting the share certificate. He should have submitted in 6 months. Imagine he did not submit. Or reporting in regulation 10, whatever we just saw, regulation 10. He has to submit, the OPI or FC, disinvestment, restructuring, or ODI, I need to submit everything. Sir, what if I have not done? Can submit with late submission fee within maximum period of 3 years. So sir, I should have submitted this year, I did not do it. You can submit it next year also, you will have 3 years time maximum. Provided if they take 10 rupees, now you need to submit it with the additional fees that is called as LSF, late submission fees. So it will be like 100 rupees plus some money. That's how you need to read it. But the maximum time given to you is 3 years. After that, sir, you cannot submit. Next one, sir, a PRI required to submit anything before the publication of these regulations. Sir, anything before that, if at all, you should have done. But imagine you did not do. Sir, whatever you should have done, people, that also you can do within 3 years from the date of publishing of these regulations. So anything before this, if you should have done, you did not do, you are given another 3 years time. Even if that you do not do in time, people, you have, that is LSF. If you should have done, you did not do, you can do it in this 3 years with LSF. Yes, sir, this is called delay in reporting. This is regulation 11. And the last one, people, is regulation 12. What is this, sir? Restriction on further financial commitment or transfer. A PRI who has made a financial commitment in a foreign entity in accordance with this Rules Act regulations made thereunder shall not make any further financial commitment, whether fund-based or non-fund-based, directly or indirectly, towards such foreign entity or transfer such investment till any delay in reporting is regularized. So, sir, until all these things are done, people, you cannot make any further investments. This is regulation 12. People, this is your ODI, new rules, people, and regulations. Basically, overseas investment rules and regulations. Is this clear, people, all of you? Yes. So read everything once, people. If you guys have any questions, please do reach out to me. Yes, people. So this is done. Now in our next part, let us focus on all the other amendments. That will take hardly some 30 or 40 minutes. If it is done, we are done with your amendments. Yes, people. Thank you so much.